Welcome to the inaugural high school moot court in Ohio. I'm Stephanie Bucher with the Ohio Supreme Court's Office of Public Information. We're coming to you from the Thomas J. Moyer Ohio Judicial Center in Columbus, where more than 70 students from 13 high schools will be participating in today's event. Moot Court is a program of the Ohio Center for Law-Related Education that focuses on the appellate court process, an often misunderstood part of our judicial system. The 2014 Moot Court case, Charlie Charleston v. State of Ohio, centers on the Fourth Amendment, which is the right against illegal search and seizure, and a hypothetical stand-your-ground Ohio law. In this year's case, a high school student arrives at his parents' house at night and sees a stranger approaching as he gets out of his vehicle. As the stranger gets closer, the student begins to feel threatened, draws a gun, and shoots and kills the stranger. When police arrive, they search the student's car and discover incriminating material. The student is ultimately convicted of second-degree murder, and in his appeal argues he acted in self-defense and that police violated the Fourth Amendment in the search of his vehicle. Moot Court incorporates both written and oral argument components. The students have submitted their written briefs in which legal issues of the case have been presented. And prior to the competition today, the students' written briefs were reviewed and scored by a panel of volunteer attorneys. Today, 16 teams will present oral arguments for both sides of the case against other competing teams. A team consists of 2 student attorneys and a timekeeper. The written briefs are judged on a number of different components, including organization, grammar, analysis, and persuasiveness. Arguments are evaluated on the application of the law to the facts of the case. Now, by focusing on the applicability of constitutional law to current legal issues, Moot Court offers the students an opportunity to develop an understanding of the Constitution and the judicial system while strengthening their writing, speaking, and critical thinking skills. And if you would like some more information about this program or any other by the Ohio Center for Law-Related Education, you may visit their website at oclre.org. Now, let's watch as our students present their arguments in the Moot Court 2014 state competition.
We're here to hear the case of Charleston versus State. Is the appellant ready to proceed? Is the appellee ready to proceed?
We are, Your Honor.
Okay. Appellant, please proceed.
Good morning, Your Honors. My name is Victoria Randall, and I am representing Charlie Charleston in this case. I will be dealing with the first issue of the motion to dismiss the iPad as evidence, and my co-counsel, Danny Barron, will be dealing with the second issue on the statute. Now, in this case, this was a case about how Charlie Charleston was convicted of shooting a man, and during that trial, evidence was admitted from the iPad that was found in his car. Now, this iPad should not have even been searched through during this case because it didn't have a search warrant issued to be searched through this. Now, through State v. Smith, it was stated that the police need a search warrant to search a cell phone. Now, also in this case, they likened a cell phone to a laptop because they have the same capabilities. Therefore, in order to search a laptop, you also need a search warrant. Now, there are no cases that talk about an iPad specifically. However, an iPad is exactly like a laptop in the fact that if you put a keyboard on it...
Exactly?
Almost exactly. Excuse me, Your Honor. If you put a keyboard on it, it has almost the same functions. You can still type up documents on it, you can message people, you can do emails, you can surf the internet, all through Wi-Fi, which the laptop also has. Also, an iPad can be like a cell phone in the fact that it is connected to the 3G network.
Yeah, but sometimes people don't use it for that capability and don't pay for that capability.
That is correct, Your Honor. Sometimes they do not pay for this capability. However, even if they don't, it is still like a laptop in the fact that it does need Wi-Fi to be able to function, just like a laptop does, because you cannot
like a cell phone.
A cell phone has 3G network. A cell phone does not need Wi-Fi. However, a laptop does.
Okay, so there is a difference.
There's a difference between a cell phone and an iPad, but an iPad and a laptop are almost exactly the same, and therefore, because they likened a cell phone to a laptop, an iPad is like a cell phone in the same manner. Okay. And then through Katz, it talked about privacy in Katz. Katz was the case where a man went into a public phone booth and police officers tapped the phone booth and listened to his phone calls. However, in this case, they decided that even though it wasn't a public space, he did have an interest of privacy in that phone booth. And therefore, because he has that interest and we as the public recognize that interest of privacy, we have to then get a search warrant because he does have that interest of privacy and we recognize that.
The police would have to get a search warrant to search a phone booth?
Not to search the phone booth, I'm sorry, but to get the calls from that phone booth. Okay.
Aren't there exceptions to the warrant requirement, though?
There are exceptions to the warrant requirement if there is a reasonable cause to be able to do this, like search the iPad or in the case of the phone booth to be able to reasonably get that call, then yes. But if there is the interest of privacy in this issue and then the public recognize it and the person has that interest, we therefore need the search warrant, which under Katz, it has those two branches of warrant cases and reasonable cause. And also there's, under the reasonable cause branch, there's a section of cases that talk about search incident to arrest. Now in this, to be able to do search incident to arrest, the items have to be on the person or immediate reaching control of that person. So if I had a bag on the table right here and I was arrested right here, right now, you'd be able to search that, but across the room you would not be able to because I cannot get to that.
Well, what if there's potentially evidence of the crime in that bag that's across the room?
If there's potential evidence of the crime, if there's reasonable cause to believe there's evidence in that bag, then you can search it. However, if it's just like I got arrested because they found out I was driving with a suspended license, as was the case in Gant, then there was no need to search that bag over there.
In this case, though, was it not a gun found next to the iPad?
Yes, Your Honor. In the car, the gun was laying on the passenger seat. However, the iPad was laying on the floorboard away from the gun. And it was not reasonable to believe that this iPad was involved in the case at all because there was no blood found on the iPad. There was nothing evident relating to the case on the iPad itself. The police could have just waited like half an hour, get a judge to sign a warrant, towed the car away so no one could reach it, and searched it then. However, they did not do that. They just went straight through and searched it themselves without waiting for the warrant.
Is it not reasonable to assume that, would you agree that seeing a gun on the floorboards gives them a reason to search the car, since there's a man who's been shot?
Yes, Your Honor. However, this iPad, you had no reason to believe that it was related to this case at all. We are investigating a shooting here, not a hit over the head with an iPad or, I don't know, hacking to do with an iPad. There was no reason to believe that this iPad had anything to do with this case at hand. Also, through Chamel versus California, a man was arrested in his house, but then the police officers decided to search the entire house afterwards. Doing this, so you can't do that. The two things that came out of Chamel were that there was direct harm to an officer, which in our case there wasn't because Charlie Charleston was locked into the back of a police car when he arrived back on the scene, and there was an imminent destruction of evidence possible. There was none because Charlie, again, was locked in the back of the car. There were no other people around. Police were all over the scene. There was no destruction of evidence possible. And also, through Thornton, they were, yes, able to search the car, as we had stated earlier, because there was reason to believe there was evidence in the car. As you could plainly see, the gun was laying on the floorboard. However, the iPad, we had no reason to believe that the iPad was then involved in this case at all because
What if it was a piece of paper with a list of people on it,
if it was
lying next to the gun?
If it was a piece of paper with a list of people on it, and you could obviously see that Mr. Slater's name was on this, that could be admitted to evidence, but this is a laptop. Mr. Charleston has a reasonable expectation of privacy in this, and we as people, we all know that we have privacy in our cell phones and our laptops and iPads as we linked them all together earlier. So if it was a piece of paper lying out and Charlie Charleston went away and then came back, he could have gotten rid of that piece of paper then because he knew it was laying out with the name on it. However, this iPad, he had an interest of privacy in this, and he knew that in order to do this, he would have to have gone.
Where in the Constitution does there a right of privacy for a laptop or an iPad?
In the State v. Smith case, it talked about how cell phones and laptops, in order to search them, you need a warrant to do that, which is also part of the Fourth Amendment. And in order to do that, and then we likened laptops to iPads, and so iPads are then linked to the cell phone itself.
Do you think it matters that he never password protected the iPad?
No, I do not, because we don't lock our front doors, but if it still gets broken into, however, it's still breaking and entering. So why not the same with the iPad itself?
But an iPad left on a table without I'll finish this question, without pass protection, anybody can pick it up and use it.
Yes, but then wouldn't you get mad if someone was looking through your documents as a person? You find someone looking through your text messages, you snatch your phone away and go, why are you looking through my messages? You have an interest of privacy in your things that you do on that.
Thank you.
May I sum up my argument?
Sure.
Therefore, Your Honors, we ask you to reverse the decision of the lower courts to dismiss the motion to dismiss.
Thank you.
Thank you, Your Honor.
Please.
Morning, Your Honors.
Morning.
My name is Danny Barron. I am representing the appellant, and I'll be dealing with the issue of statutory interpretation. Now, we're here today because my client, the appellant, was robbed of his right to a pretrial conference. This decision to waive his right to a pretrial conference was not harmless error. And I'll prove this to you by going through a list of topics. 1, the Ohio Standard Ground statute requires a pretrial conference. 2, that the appellant was immune not only to conviction but also to criminal prosecution. 3, this was not harmless error because the appellant could have avoided the painful trial process. 4, immunity should not have been discussed during trial but instead during a pretrial conference. 5, the appellant met the requirements for a pretrial conference. And 6, the facts that could have possibly been presented in the pretrial conference could have altered the outcome of the bench trial. Now, the Ohio Standard Ground statute, statute number RC 2999.32, states that a pretrial conference is necessary. It states that one who obtains immunity is immune from criminal prosecution and conviction. Now, if one is immune from criminal prosecution, then it wouldn't make sense to discuss the topic of immunity in the trial itself, because if immunity was obtained during the trial, then the appellant was never immune to trial in the first place. It doesn't make sense. And Ohio Standard Ground statute is very similar to that of Florida's. Florida's specifically states that a pretrial conference is necessary, but Ohio took the statute and sort of removed the phrase that specifically mentions a pretrial conference. But in Ohio statute, a pretrial conference is still necessary because it specifically states that one who obtains immunity is immune from criminal prosecution. So something must happen before the trial to obtain immunity.
So the pretrial conference was taken out of from the Florida statute, is that what you're saying?
No, from the Ohio statute.
It was taken out, but it was in the Florida statute.
Yes, it was.
It was taken out. Isn't that an indication the legislature intended that there be no pretrial conference
It is not, Your Honor, because,
in its wisdom?
oh, no, it's not, because within the Ohio statute, it still states that one who obtains immunity is immune from criminal prosecution. That means from trial. So if one is immune from trial, then something must happen before the trial itself that would allow the appellant to obtain immunity, and that would be a pretrial conference. Now, the appellant is immune from not only conviction but also criminal prosecution, as I stated earlier. I'm going to repeat this point many times. And immunity was discussed within the trial. This was in itself, I think, is grounds to overturn the decision of the lower court, because immunity should not even be a factor in the trial itself. Immunity should only be discussed within the pretrial conference, as stated by the statute. This violates the statute.
Wouldn't a trial, the jury have a right to determine whether you have to have reasonable expectations, correct? Reasonable fears before you can invoke the immunity statute?
I would say no, Your Honor, because the subject of immunity should only be discussed within pretrial conference, and after that, if immunity is not granted, then we know for sure that the one trying to obtain immunity did not use deadly force.
But if there's a fact dispute whether the person was acting reasonably in that fear, don't we have juries to determine that?
We do, but in this case, the trial itself was a bench trial, so the jury is not a factor. Now, the decision to rob the appellant of his right to pretrial conference was not harmless error, because the appellant still had to suffer through the long and painful trial process. And this also cost the state a lot of money. We spent hundreds of thousands of dollars putting this person through trial. And if the appellant could have obtained immunity in a pretrial conference, as I believe he would have if he had the opportunity, we would not be in this issue right here. And the Supreme Court case, Dennis versus the state of Florida, states that the existence of disputed issues of fact did not warrant the denial of a motion to dismiss asserting immunity. So just because we are unsure of the facts of whether the appellant acted out of self-defense or not, does not allow the judge or whoever to rob the appellant of his right to a pretrial conference. He is still entitled to the right to a pretrial conference. Now, as I stated earlier, immunity cannot be discussed in trial at all. The subject of immunity from criminal prosecution cannot be discussed during the criminal prosecution itself. That just doesn't make sense. If granted immunity, he still had to endure the trial that he was supposed to be immune from in the first place.
But someone has to factually determine whether he's met the burden that he qualifies for immunity.
Yes, he does. And the appellant did have a preponderance of evidence that he could have presented in a pretrial conference. I'm not going to go into the details of those facts because, frankly, I don't believe that they matter, because we're dealing with the fact that he was robbed of his right to a pretrial conference. He was prepared to argue in a pretrial conference that he did murder Slater in self-defense, but he just never had that opportunity.
Well, he could do it. I mean, I realize in theory he shouldn't have to do it at trial, but if he's been denied the pretrial conference, why not do it at trial?
Because even if he did obtain immunity during the trial, he still had to endure the trial. So if he did obtain immunity during the trial, what is he immune from? Conviction. And that violates the statute, because one who obtains immunity under the Ohio Standard Ground statute is immune from both criminal prosecution and conviction. And the appellant did meet the requirements for pretrial conference. As I stated earlier, I'm not going to dive into the facts of what happened during the death of Slater, because frankly they don't matter, because he was robbed of his right to a pretrial conference, and he did have the burden on proof on the subject of immunity, and he had to prove that he was defending himself, which he did have those facts, but he just was never given the opportunity. He was robbed of this right. And the facts presented during a pretrial conference could have altered the outcome. If the appellant had been given the opportunity to present the facts regarding self-defense before the actual trial itself, then the judge may have decided differently, because he was actually exposed to the facts of self-defense before the trial. And a pretrial conference can also serve as the opportunity for one to present the option of self-defense as a motive to the judge and/or jury. Now, Your Honors, the appellant was unrightfully robbed of his right to a pretrial conference, and we therefore ask that you please overturn the decision of the lower court. Thank you.
Thank you. Any questions?
No.
Thank you.
Thank you, Your Honors.
Counsel?
Your Honors, opposing counsel, may it please the court. The appellee respectfully disagrees with the appellant. We submit that the facts of the night in question.
I have to say that's a surprise. Go ahead.
We submit that the facts of the night in question indicate that the use of deadly force by Mr. Charleston does not fit within the confines of Ohio Revised Code, Section 2999.16. This would, of course, mean that Mr. Charleston would not be immune to criminal prosecution or civil action. Ohio Revised Code 2999.16 lays the ground rules for the use of deadly force for self-defense purposes. Part A of Code 2999.32 states, a person who uses force as permitted in 2999.16 is justified in using such force and is immune from criminal prosecution and civil action for the use of such force, unless the person against whom forced use is a law enforcement officer. While it is obvious that Mr. Slater was not a law enforcement officer, this does not necessarily mean that Mr. Charleston is immune to criminal prosecution or civil action. In order for Mr.
Well, let me ask it this way. If the legislature clearly wants the shooter to be immune from criminal prosecution, correct? It says it in statute, correct?
Correct.
But if there's no pretrial finding that immunity applies, how does anyone ever prevent them from being immune from criminal prosecution?
Well, right in Part A of Code 2999.32, it does state a person is only immune from criminal prosecution and civil action if their use of force is permitted in Code 2999.16.
How do they prove that?
They would bring that before a court of triers of facts, and they would, assess the facts and determine whether or not they felt that this person should be immune from criminal prosecution.
A pretrial hearing?
This could be the way that this is done, but a trial of juries would certainly work for this.
Well, then how's the person immune from prosecution if they have to go through a trial to prove that they're immune from prosecution?
If it is found that they're immune from criminal prosecution and civil action, they would be compensated for their time and monetarily.
But there's nothing in the statute about that, compensation for their time.
No.
Okay.
In order for Mr. Charleston to be eligible for this immunity, his use of force would need to fit within the confines of Code 2999.16. We contend that appellant's use of deadly force does not comply with this code. This case is incredibly similar to the case of Dennis v. State. In this case, the triers of facts, a jury, determined that the plaintiff's use of force did not fit within the confines of the law, and immunity for this individual did not apply. For this reason, it is relevant because the Court of Appeals ruled that because this individual failed to submit any new facts into evidence, the fact that this person's immunity was determined in his court hearing, it was permissible. The only thing that is different about our case is the factual evidence itself. Like Dennis v. State, appellant's lack of immunity was determined in a court hearing, and like Dennis v. State, appellant has not presented any new factual evidence to his Court of Appeals. Appellant was also tried before a jury in his trial. These triers of facts were presented the factual evidence of the night in question and determined that he was not immune to criminal prosecution or civil action.
Did you just misspeak? Mr. Charleston had a bench trial, did he not?
He did, yes. I apologize for that. And determined he was not immune to criminal prosecution or civil action, much like a judge would in a pretrial conference. Appellee contends that the appellant should not be immune to criminal prosecution or civil action on the ground that his use of deadly force was not permissible under Ohio Revised Code 2999.16, and on the grounds that his immunity was determined in a fair way. I would also like to draw the court's attention to the stand your ground laws of the state of Florida. This is relevant because these stand your ground laws were introduced and examined in Mr. Charleston's bench trial. Appellee submits that these laws are essentially the same, save several inserts of the word and things like that. Essentially, these Florida laws state, a law enforcement agency may use standard procedure for investigating the use of force as described in subsection 1, but the agency may not arrest the person for using force unless it is determined that there is probable cause that the force that was used was unlawful. The triers of facts in his trial, a jury, found that his use of force was unlawful. and the police on scene clearly saw this and arrested the individual so he could be prosecuted. Do Your Honors have any further questions?
Anybody? Thank you.
No.
Thank you.
Your Honors, before my time begins, I'd like to introduce myself and my co-counsel. My name is Kristen Langlois, and my co-counsel is Aaron Moot. Your Honors, opposing counsel, may it please the court. And the issue I would like to address in today's case is whether the evidence obtained from the appellant's iPad was collected legally without a warrant. We submit that the search of the appellant's vehicle was lawful without a warrant due to the precedent established in the Supreme Court's decision of Arizona v. Gant. In this case, the Supreme Court stated that a vehicle may be searched by police officers if its recent occupant has been arrested and/or the vehicle may contain evidence of the offense of the arrest. In today's case, the appellant drove to the crime scene, was then questioned, and then arrested and placed in the police cruiser. Officers then searched the vehicle and found a gun in plain sight, and also an iPad a mere foot away. Furthermore, due to exigent circumstances, officers searched the appellant's vehicle.
Let's talk about exigent circumstances. How was it exigent circumstances if he was locked up in the police vehicle?
Someone could have come up and someone, possibly part of his family, could have come up and drove the car away, and therefore the evidence gone.
Couldn't the police have just posted an officer there until a warrant was located? A judge was located to issue a warrant?
Yes.
Or couldn't the police have towed the car and to the impoundment lot and held it there?
Yes. Due to the fact that the gun was in plain sight, officers then had reasonable suspicion that other evidence may be obtained through searching the vehicle.
What reasonable suspicion linked the iPad to the gun?
The fact that the iPad was only a foot away, the gun was on the seat, the iPad was on the floor, and the iPad was on.
Was the iPad going to shoot the gun?
No. The iPad being in such close proximity and being on suggested that possibly the iPad may have been used in the use of the gun. It could have supported the use. It could have it could have caused the use of the gun. Continuing, in Katz v. United States, Justice Potter Stewart stated for the court, "The Fourth Amendment protects people, not places." We contend that because the police officer's search of the appellant's iPad was conducted during the search of the appellant's vehicle, a place, not a person, therefore the iPad does not fall under the Fourth Amendment. Also, the iPad
Aren't cell phones protected?
Yes. Yes.
Well, then
But
what's the difference?
an iPad is not a cell phone. An iPad does not necessarily connect with 3G or 4G. It is...
But neither does a laptop.
No. A laptop is... because the iPad was on and it was in close proximity to the gun, police officers had reasonable suspicion, and since it was not locked in any way, it suggested it was almost like if Katz left the door open to the phone booth when he was making a conversation. The appellant left the door open for police officers to search his iPad.
So if I leave my front door open, the police can just come in?
And a house is different than an iPad. A house
I leave
is
my hotel door open, and they think I'm driving on a suspended license. Does that give them the right to come in without a warrant?
no. Police officers must first assess the danger of evidence being lost or due to exigent circumstances or due to probable cause, officers must assess whether there is reasonable suspicion to search an area or an iPad in this case. Next, we submit that the expectation of privacy of the defendant's appellants was lower due to the fact that it was not password protected. If the device is not password protected, there is generally if the device is password protected, there is generally a higher expectation of privacy than a device that is not password protected. Continuing, the police officers had reasonable suspicion that the iPad may have played a part in the issue of the gun being used due to the close proximity, only a foot away. Because both items were found in plain sight, it gave the officers reasonable suspicion that the iPad and the gun may have been used in some, well, obviously the gun, but the iPad may have played some instance in the events that followed. Finally, we contend that the search of the defendant appellant's vehicle was lawful due to the fact that it was conducted as a search incident to a lawful arrest. Do Your Honors have any further questions?
No.
No.
Thank you.
Thank you. Any rebuttal?
Yes, Your Honor.
Thank you.
Your Honor, the opposing counsel argued that the appellant's use of deadly force was unreasonable, and they brought up some facts. But frankly, the facts do not matter. My client, the appellant, was always entitled to a pretrial conference, no matter what the facts say. He had his facts prepared, and he was ready to try and obtain immunity. And you cannot prove or disprove immunity without a pretrial conference in the state of Ohio. The definition of immunity under the Ohio Stand Your Ground statute doesn't allow for this.
Then why did the legislature take it out from the Florida statute?
Well, Your Honor, frankly, we cannot say that for sure, but a pretrial conference is still required because of what the statute says regarding immunity from criminal prosecution.
So what is the difference between Mr. Charleston having successfully proven that he was entitled to the protection under the Stand Your Ground statute at a pre-trial hearing versus whether he successfully proves the same facts at his trial?
The difference is that if he did obtain immunity during the trial itself, he would have never been immune under the Stand Your Ground statute, because immunity, the definition of immunity in Ohio, is immunity from both conviction and criminal prosecution. He still had to endure criminal prosecution, and whether he obtained immunity in criminal prosecution or not, well, if he did, he would never have been immune in the first place, because he would have been immune from conviction, but that's it. And that's not immunity in the state of Ohio. And any Fourth Amendment violation must be remedied by exclusion of the evidence that's debated. Also, if we assume that the decision to rob the appellant of his right to a pretrial conference is harmless error, then how can we ever enforce this statute in the future?
Do you not see, or I think the two issues that you've raised on appeal are separate entities. We could agree with you and overturn the failure to suppress the evidence on the iPad, and he's still possibly facing a murder charge, correct?
He could have, because actually proven, because he was convicted of second-degree murder, even though the evidence of the iPad was submitted in the trial. But the fact remains that the evidence found on the iPad was obtained illegally, and that evidence, the use of that evidence does violate the Fourth Amendment. So to remedy that, that evidence must be excluded.
But we could still send it back for the immunity hearing, correct?
Yes, we could.
Okay. I guess my point is dismissal's not the only option we have. Wouldn't you agree?
Absolutely, absolutely.
Is the appellant asking for a new trial? Is that the goal?
Well, we would, in the first place, be asking for a trial, but yes, before that, even so, a pretrial conference to make sure that he is given his right. And also, in the Supreme Court case, the state of Heinzelman versus Air Expert, Air Expert's an air conditioning company, installed a unit in the Heinzelman home, and Heinzelman, while operating the unit, was electrocuted. And a confusing statute made suing difficult for the Heinzelmans. They wanted to get compensation for the fact that the unit was installed improperly. And the court ended up ruling that the first duty of statutory interpretation is to determine that a statute is clear and unambiguous. Ohio is very clear when it states that one who obtains immunity is immune from both conviction and criminal prosecution. So therefore, one cannot rely on the ambiguity of the Ohio statute because those examining the statute during court made it very clear. Not in this case, but in previous cases. And, Your Honor, do you have any final questions?
Question?
No.
Well, you're telling us the statute's unambiguous, but it very clearly leaves out any mention of this hearing. So aren't you also arguing that it is ambiguous?
No,
that
Your Honor,
respect?
I am not, because it is clear it is unambiguous when it doesn't specifically mention a pretrial conference, but it is implied that one is needed if it states that the definition of immunity is immunity from a trial in the first place. So for one to obtain immunity from criminal prosecution, one must establish immunity during a hearing before the actual trial itself.
Thank you.
Thank you, Your Honor.
Thank you. The other scoring judges will leave the room. It just comes at you relentlessly, doesn't it? But that's part of being, actually, it's part of being a lawyer. It's part of your life. But y'all did great. We have a few comments, general comments for everybody. And why don't we start with Julie this time?
I think I was very impressed with all four of you. Obviously, you were nervous, and everybody started out that way, and you all recovered very, very well. I was telling the other judges, I never did this until I was in law school. And I was 26, 27, something like that. And I was so nervous that I fell off my very low shoe and sprained my ankle at the beginning of the argument. So I'm constantly impressed with the poise and the confidence you have. I think I spoke like this about the whole way through. So even if you were nervous, it didn't come across, and that's a good portion of being an effective lawyer. If you let the other side or the jury or anybody know that you don't have confidence in your case, they're not going to have confidence in your case. Just a couple of slip-ups, and only because I want you to always remember about this. Danny, you did really well. I don't practice in Ohio. I was a lawyer and a judge in Washington State. In Washington, it is reversible error to, in an argument, say, I think. You need to say the law says or the facts show. It's kind of irritating on one level because jury's going to sit up there and say, I don't care what he thinks. I want to know what really happened. So just kind of watch that. It's easy to do, but it's something that you should watch. Victoria, you did a really good job linking a cell to a laptop to an iPad. It was one of the best we've heard about, no, the case doesn't exactly say it, but we can make this analogy. And I think you did a really good job with that. Another very good segue to the Gantt case. You took the facts from a question and linked it and made a very good point. Aaron, you did a really good job. You knew the law. You were able to do that. I think nerves got you because you didn't introduce yourself.
Yes.
And Kristen, you saved it. Obviously you were over there thinking, I need to take care of this, I need to help my partner, and that's what good teams do, is you're both here to make your side of the argument, but it doesn't work if you don't work as a team, and you guys did a very good job of doing that. Kristen, we tried to rattle you, and it didn't happen. You handled yourself very, very well. I don't know, I've only done one appellate argument. And I think we probably were rougher on you than a lot of judges would be on attorneys. And it wasn't intentional. We weren't trying to be, but you handled it well. Both of you did. So I want to congratulate all 4 of you. I think you did an excellent job.
I'll echo everything that has already been said. Just going through my notes, Victoria, you did very well. You started out a little fast. You're trying to get everything, you know so much, and you know all the law, and you just wanted to get it out, and just slow down. Just, you're up there, you know what your argument is, be confident in it, and just tell it to the judges. We already touched on the I believe. That's something that I was taught in law school to never say, and it's such a natural thing to say, and I get it, especially when a judge says, well, what do you think, or do you think this? It's hard not to say that, but your job is to present the law and why the law should be applied in a certain way to the facts. Both of you did a good job of anticipating what the appellee was going to argue and addressing what the appellant did argue in both of your main arguments, and especially in the rebuttal. It's good to anticipate what the other is going to say and not be locked into what your planned remarks are, because as you know, as soon as you get up to the podium, what you plan to say could go out the window with judges' questions, with what the other argument was. So you did a very good job of anticipating and reacting to what happened here today. You all have very loud, confident voices. You did a good job with that. That's all I've got. Good job.
Mine are going to be more general, but I want to tell you, I don't know if it's because it's the second round and you've had a chance to do a first round, but I'm proud of the education our high schoolers are getting in Ohio, because you guys are very good. And I wish I had had these opportunities when I was in high school, because they didn't exist. I thought everybody started off a little fast. And you got to remember, I see, I don't know, 12 oral arguments a week of seasoned lawyers. And so I may be unfair, okay, because you're nervous. But just, I think somebody said it, slow down your initial sentence or two. Just take a deep breath, and you'll be fine, because you all know this stuff. You know it well. And you don't just have to spew it out to us as fast as possible. I know there's time constraints, but it's the quality of the argument that matters more than the quantity. And I thought, and I do think you, by accident, we ended up giving you a withering set of questions, but you handled it. It kind of rattled you a little second, but you recovered. And I think somebody asked something about a statutory interpretation. Somebody, yeah, you, and you handled that well too.
Very well.
I always tell people, and I was very successful appellate lawyer. I argued in the 2nd Circuit in New York City, the 6th Circuit in Cincinnati, 10th Circuit in Denver. Had a case in the U.S. Supreme Court, didn't have to make the oral argument there, and I've argued in many of the district appellate courts here in Ohio. Next year, before you come to this, just have a couple lawyers sit down and act like us and ask you questions. And if you've done that, that's a good thing, because I noticed with you all, it seemed like you at least had generally thought out responses to questions. And that is an important, it's kind of a moot court for the moot court. And I helped the team from the University of Cincinnati Law School. They won the national title. And they driving back from Buffalo or wherever it was, called me up and said, Judge, we knew every question they were going to ask because you went through it twice with us. And that's a good way to prepare for these, just like you would. And I can tell you, in the major law firms, when I was in a big law firm, that's exactly what happens. They'll get 3 of the lawyers who aren't involved in the case, give them the briefs, and they act like a court of appeals and prepare you. And I don't know if you guys did that, but it sounded like you did to a certain extent because you guys seem to know what you're doing. And that's very important. And you should be proud of yourselves because you're doing very, listen, in the argument we just heard, you were better than half the lawyers I hear on a regular basis. I mean that, I'm not joking. I guess it's being recorded. I'm going to get.
You're in trouble now.
I'm in trouble now. But you came so prepared, and sometimes the lawyers don't, because to them it's old hat, so they don't prepare. But you guys know what you're doing. You should be proud. Thank you.
Well done.